Welcome to Legal 123s with ByrdAdatto. Legal issues simplified through real client stories and real-world experiences. Creating simplicity in 3, 2, 1.
Welcome back to another episode of the Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd.
As a business and healthcare law firm, it's important to focus on the details. This season's theme is zoom in. Once we know our big picture vision or strategy, we have to roll up our sleeves to get the work done. With each episode this season, we'll have our typical stories and make sure we talk about specific actions to focus on for 2022.
Yeah, and the details sometimes can be very cumbersome, Michael, because it takes some of the fun out of the big picture, the vision that you're having. And in today's episode, the devil was in the details, and had the parties spent some more time examining all these details, they may have not have done the deal altogether, or with each other at least. And then, Michael, in this episode, unfortunately, we're going to use a ton of legal jargon,
AKA power drain. Yes. So I love the big picture. Do not love legalese.
Yeah, I could see that. And when we first met in 2005, when we were interviewing, or maybe it was one of our first conversations, I guess, when you were seriously considering adding me to the team, you had asked me if I used plain language when working on my legal documents. And at first, I thought you didn't think I spoke English because I'm from New Orleans, and in Louisiana, most people think we still practice under the Napoleonic Code, which is untrue.
Well, first, Brad, who doesn't ask about plain language on a first date? I mean, come on. But I want to go back to your last statement. Which part is untrue? Because we all know you don't speak English. You speak Brad.
Okay, fair enough. Louisiana is not governed on the Napoleonic Code, so that's untrue. And I guess it's true that I don't speak English. But I was not, at the time, I was not familiar with the concept of plain language.
Well, let me give some context here then.
Yes, we all know that you love context. No one who listens to this episode is even surprised by that statement.
Okay, well, so this takes me back all the way to law school, and we had to do legal writing, which is not normally an impactful experience, but we had a professor that was big on the whole plain language movement. And that the idea is, hey, just because you're a lawyer doesn't mean you have to use fancy words. Why don't you just talk like a regular human being? That was the gist of it. Mm. And it seemed to make a lot of sense to me because at that point in time, I was still just a regular human being. Yes. I wasn't a lawyer yet.
Yes, you weren't warped yet.
But so I tried to adopt that. As you know, in my early years, I was a litigation attorney, and you're making arguments to the judge. And I thought, hey, this is a great time to just be super clear and super concise as to what my points are. And, it's not like it was some contract where you had this feeling like you had to use fancy words to make it enforceable. We were just arguing before the court. So I got a pretty well-developed habit of doing that. And as you know, I started doing transactional work. Mm-hmm. And along the way, I was trying to adopt it there, but then I actually had in one of my court cases what we call a Rule 11 agreement, which is a contract with the other attorney. And the other attorney was constantly missing deadlines to turn over documents. And finally, I had enough. And I was like, okay, fine. Here's the deal. I'll give you one more extension. Mm-hmm. This is probably the 5th extension. And if you don't meet this deadline, you agree by contract to dismiss the case with prejudice, which I was like, okay, well, if he misses it again, this case is over with. And guess what, Brad? He missed the deadline again. Yeah. So I tried to enforce this contract written in super plain language. I won at the trial court. He appealed it to the Court of Appeals, and I won at the Court of Appeals. And there was some controversy about whether an attorney could agree by contract to dismiss a case with prejudice. And so that gave me kind of the wind behind the sails of, yeah, I'm all in on plain language. And Unfortunately or fortunately for you, our first date was not long after that.
Well, I guess in that contract, if you had like all these cool, awesome words like aforesaid, hereof, hereby,
Yeah,
whereof,
would not use those words,
No?
Brad. No.
Those are great little legal
Or
words.
run-on sentences, which had exceptions to the exceptions to the
Oh,
exceptions.
I hate those.
By using plain language, we could and did eliminate the use of outdated legal jargon and legalese in favor of drafting documents in clear, concise, and modern English, or as I said earlier, like a real human. Our clients loved it because they would routinely call and say, "Hey, this is the first contract I've ever read where I actually understood what was happening." And so it allows clients, regardless of their sophistication with working with lawyers, to really understand what's going on without the frustration, confusion, and need for lengthy explanations of what in the world the documents say in the first place by the attorney.
Yep.
And most importantly, they could concentrate on the core terms and conditions and not, trying to read a foreign language.
Yeah, and we've all heard that term, ignorance of the law is no excuse. Well, this holds true, and if you have a documentation that the draft is using of these obscure language that an ordinary human can't understand, and that means the parties just simply don't understand what they're getting into when they enter that agreement. So who's to blame? Probably the drafting attorney. That's his job to make sure that everyone understands what's going on.
And to be clear, plain language should not carry any connotation of the agreement as being dumbed down. We're not reverting to kind of Cat in the Hat and Dick and Jane style of writing,
which is good stuff too.
Yes, for sure. We're not trying to pander to the lowest common denominator. In fact, it's quite the opposite. It takes a lot of work to say what you mean in clear and concise language. So, Brad, even though today we could be using a lot of legal mumbo jumbo, let's work hard on using some plain language.
Perfect. I will work very hard of trying not to use the legal mumbo jumbo. And for those who are listening to this, if we do throw some legal jargon at you, just remember, like every episode that we do have a running. In this episode, there'll be a transcript at the bottom of the notes section. So if we say something that just doesn't make sense, feel free to pause and read it, or go back and later read any definitions that we might use today. But Michael, if you're ready, let's get going.
Brad, our client in this story today is a board-certified orthopedic surgeon who had a strong focus on spine surgery. We'll call him Dr. Spine.
Perfect. Spine doctor equals Dr. Spine. I think we all got that one.
Yeah, not feeling too creative today, but we all get the point. Yeah.
Yes.
So our client was looking to develop an outpatient surgery center, commonly called an ambulatory surgery center or an ASC.
So we're starting to get to some of the legal jargon, but so those not familiar with the term, this is a medical facility that is used to do, a lot of times people call it day surgeries. You're admitted basically within a time frame of the day. You're discharged basically the same day, technically 23 hours, but meaning that you can't have an overnight stay of that person like a traditional hospital, which probably most of you guys are familiar with. So typically you have several surgeons or invasive providers who need to have an ambulatory surgery center. And to do well, they need a lot of them. Otherwise, it won't survive, meaning the ASC won't survive and won't be profitable. And those who probably have listened to other episodes, you might have heard us talk about the corporate practice of medicine in those episodes. Just remember, the difference here is an ASC is a licensed facility by the state. And as such, anyone, even two lawyers, could own it. So it means that physicians and non-physicians can own an ASC together. So a little sidebar to make sure everybody understands, because it's going to be important as we go.
Yeah, good point. And here, Dr. Spine, he had a number of surgeries that he could do in an ASC. And just, again, quick pause for context. There are some cases that you got to do in the hospital because of just the nature of recovery that goes with it. And so obviously you want to make sure you have a fit there with what the types of cases you do. Yep. But he was a solo spine surgeon and he didn't have enough on his own to single-handedly, operate his own ASC.
Mm-hmm.
So he can invest in one, or he could build one and get other doctors in. And he determined to build his own, and he actually reached out to a third party to help coordinate the process, including the building, the funding, and the managing of the ASC. He hired a group whose main contact we'll call Mr. Network.
Ooh, I like Mr. Network. Hopefully he knows lots of good physicians. And for context, as Michael was explaining, that when a lot of times when these physicians partner up with these third parties, there's basically three different ways in which we see the structure of this. So sometimes the physician owns the majority of it, but has that third party help kind of run it day to day, and they are going to go out and find those other new potential physician investors. And when they do, they dilute the physician. Or other times, the ASC third party wants to own the majority of it, so the physicians are the minority of it. And if they go out and find more people after managing it, the third party gets diluted. And then we have the less common structure where the doctors have a more minority interest in the ASC. The third party again runs it and then goes out and finds other physicians to invest in it. But then, even though the doctors, their minority portion, they would get diluted. So, to be clear, there are other options if you're doing a deal with a hospital, but it's not really related to this episode. So that's three different type of models that we typically see.
Well, and of course, this story was enough to make it into a podcast episode. So guess what? It was one of the less common models.
Mm-hmm.
This is one where the doctor had a minority share and the third party had the majority. And when the units were sold, it would dilute the physicians.
Yeah. And so for this third model, if it is used, everyone needs to be on the same page as to what is their jobs. So Dr. Spine, he was so crazy busy, he didn't have the time to really get into this. This is why he partnered with this group and basically let them have these large shares, because he couldn't be distracted by the day of running it or finding these doctors or actually making sure that the facility's up and running correctly, which is the whole reason why he partnered with Mr. Network.
So let's fast forward a little bit.
Mm-hmm.
The ASC is getting ready for funding, but so far at this point, Mr. Network has only found one other physician investor, and he was a double board certified in physical medicine and rehabilitation, but not a surgeon. We will call him Dr. Payne.
Good name, as he became a big pain for our client. But Michael,
Dad joke.
Mm-hmm. But Michael, I want to pause a moment. I think when we started this, we said that Dr. Spine had hired Mr. Network to find other surgeons or invasive providers to make this ASC profitable. They only had two doctors, and they're different specialties. How does that work with different specialties?
Well, it can work well most of the time. The parties have to understand that when developing the ASC, the type of outpatient services provided will drive the equipment decisions, the spacing, and the staffing needed.
Yep.
And so failure to understand this detail, zoom in, Brad, can be huge. Additionally, how you bill and collect for these procedures can be impactful. And so are you going to be, as an example, are you going to be in network or are you going to be out of network?
Okay, Michael, generally, we should stop and give a really long explanation about the differences between in-network and out-network and the pros and cons of that. I think we're going to do a whole episode this season on that. So, but for those not familiar with that term that Michael just used, as a very quick explanation, often your physician or this facility would have entered in some type of insurance arrangement, we're known as in-network, with that health insurance provider, and that insurance would then reimburse them based on some predetermined contractual amount. If they don't have agreement with that particular group, but the patient does, and they want to bill for that same service, that would be considered out of network. So that's kind of a baseline understanding of in network and out network. Again, we'll do a whole episode on this season. But in this case, this third party, so their job should be helping administer and leveraging their other relationships, Mr. Network here, with other commercial payers to get the best in-network contract for the ASC.
Okay, so back to where we were. Mr. Network convinced Dr. Spine at this point, with only one other doctor, hey, if you build it, they will come. that once the ground broke, it would be at least 6 months before they open, and they would have plenty of time to find more physicians. Fast forward to 10 months later.
That's more than 6.
It is, Brad. Good math.
Okay.
Yeah, good. Even for a Louisiana boy, I'm pretty impressed. And they're getting ready for their soft opening at this 10-month mark of the ASC.
Yeah, and this is, I remember this moment really well. Actually, you were out of town. So Jerry, our partner, and I went to go see this new facility. Dr. Spine was pretty excited about finally getting it. It's a soft opening, so it wasn't officially completely done, but enough so that we could kind of walk through it. And we were part of it. We helped obviously review a lot of the documents when it came to the deals for the real estate or the commercial loans, and some of the other governing documents that were ones that he had to sign. And so to us, it felt like we were part of it, even though in reality, once everything was signed, the next 6-10 months, we were not part of that process. But it was great just to kind of be there.
And I remember you calling me from the car after you left the facility, and you and I were both in shock.
Yeah. So first, Mr. Network, as Michael had already said, he still hadn't even found another physician provider or investor to get in here. So that's kind of was one problem. That was the first time we learned about it when I was there. Second, the rooms were really jacked up. And what I mean by that is there was just one huge room for all orthopedic services and several small rooms, a lot of, like the majority of this facility was for these pain procedures. And that's somewhat common, meaning that you could have that if you're a pain clinic and you want to have these procedure rooms. The issue was when Dr. Spine really started getting into this deal, there was supposed to be more than one orthopedic service room because he needed, if he wanted to do multiple patients, you have different rooms for that. And there was just one. And there's really no discussion in all these small pain rooms that were developed.
And as what happens so often, in stories like this, Dr. Spine was busy with his clinic and he was not paying attention to the build out. But Dr. Payne, on the other hand, was working hard at telling Mr. Network how he could get a ton of pain doctors to invest in this ASC. So Mr. Network pivoted this ASC from a spine-focused ASC to a pain-focused ASC.
Yeah. And additionally, most of the time, if a medical services that Dr. Payne was going to provide, unfortunately, the insurance companies wouldn't reimburse for it because at the time, a lot of these things were too aggressive or are not approved yet by insurance providers. All these details expose that Mr. Network didn't have really an actual network of physicians or physician investors that he had talked about when he sold Dr. Spine on this idea. And he truly, it looks like, didn't really understand, all the actual details, zoom in, of actually setting up an actually profitable ASC.
Okay, so let's fast forward again. As the audience can predict, this does not end well for Dr. Spine. The revenue for this ASC was not adding up. Dr. Spine's surgical services at the ASC was barely keeping the lights on, and the business was going backwards. Dr. Payne's services were not reimbursed at the level they wanted, or sometimes even at all. Mr. Network had not found another doctor to provide services or invest, and things looked dim.
Yeah, so here is Dr. Spine working his tail off, keeping the place open. He's a minority owner. And this finally starts leading to, him being a little frustrated. And so what does Mr. Network and Dr. Payne, they go out and try to find some creative ways of turning up business because Dr. Spine's kind of aggravated with them, which we'll just say ethically questionable ideas or outright could actually harm the overall ASC's license issued by the state.
Yeah, usually when you are doing questionable things in healthcare, it's not a good thing. So Dr. Spine wanted out. Even though there was a ton of debt on the ASC, the facility was not going to make it. So let's go into a commercial, and on the other side, talk about the details he should have considered when developing a properly licensed ASC, and what type of investigation Dr. Spine should have conducted with Mr. Network before he entered into this deal.
Many business owners use legal counsel as a last resort rather than as a proactive tool that can further their success. Why? For most, it's the fear of unknown legal costs. ByrdAdatto's Access Plus program makes it possible for you to get the ongoing legal assistance you need for one predictable monthly fee. That gives you unlimited phone and email access to the legal team, so you can receive feedback on legal concerns as they arise. Access Plus, a smarter, simpler way to access legal services. Find out more. Visit ByrdAdatto.com today.
Welcome back to Legal 123's ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd.
Brad, we just discussed a troubling story of all the issues that went wrong for Dr. Spine. For our audience, let's give them a small taste of the rules which govern, and Brad, I said small, a small taste of the rules which govern the ASC world when physicians are investors. And remember, Brad, please use plain language.
I will do my best here, Michael, to use plain language. And then for our audience to understand, there are basically two main federal laws that you'll hear people discuss in this industry. And they're more than that, but those are the ones that people look to. One is called Stark, which is basically the federal anti-referral law. And the other one is called the Anti-Kickback Law, which is the one that it is what it is. But the Anti-Kickback Law is actually more relevant to today's story. So we're just going to focus on that and not worry about Stark today. So that will help with keeping it as simple as possible. But for those who want to understand what is the Anti-Kickback Law, really, it prohibits directly or indirectly offering or receiving of value in exchange for anything to really induce anyone to refer to a facility where you have financial arrangement. And I'm paraphrasing, the thing goes on forever. The law applies to everyone, so not just physicians. And the federal government has used this law over the life of it because it's so broad. They love to use this as a way to prosecute people both criminally and civilly.
And I am truly dumbing it down, but it's essentially this: you can't pay for referrals.
That's it.
So how do you protect yourself?
So when these laws came out, a lot of people were freaking out about how do I protect myself? What do I need to do? So the government said, okay, what we're going to do is we're going to create these, quote, safe harbors. And if this arrangement falls directly within a safe harbor, then you're immune from prosecution and administrative fines. So great, that's good. And this is different than Stark law. Again, little legal ease here, that Stark law has Stark exceptions. If you fail to meet one Stark exception, it is illegal. But if you fail to meet one element of a safe harbor, it doesn't make it per se illegal. But to be clear, the safe harbor is there so that you can try to structure your way to be most compliant.
And so just, Brad, again, dumbing it down, because these doctors are billing for operating and they're their patients that they're treating, and then they're referring it to a facility that will also bill for it. We have to deal with this because that's a referral.
Yep.
And so what safe harbor did they need to meet based on, kind of today's facts?
Yeah. And just for the audience, again, there's so many different safe harbors. So depending on what structure you're in, and the government has come up with these safe harbors for ambulatory surgery centers. And so there's some basic elements of everyone. I'm going to keep it really high level. But number one is ownership must not be related to the volume or value of those referrals. Number two, you, the organization, and the other investors can't loan someone money to invest in that ASC. The distributions need to be made based on their pro rata share of ownership. All ancillary services that are performed there must be related or part of the primary practice of that surgeon. And finally, the physician must disclose their ownership with those patients. So that's a really brief one. If you're a healthcare lawyer, you're probably laughing because I left some things out, but trying to keep it as simple as possible, because otherwise, Michael, we get legal ease and then people stop listening.
Oh, good grief, man. I mean, it's still heavy. I'm like about to fall over. Is that all?
No, of course not. I mean, remember we talked about the exceptions. Well, as these different ASCs come together, they're saying, look, if you're making this an extension of your office, you, the physician, we want to make sure it truly is an extension of your office. And so they came up with, Michael, the 1/3 test. Gotta love these things. And so as a 1/3 test, you have to meet it to be compliant. And so because, as we talked about earlier in this episode, this is a multi-specialty because we have a spine surgeon working with a rehab doctor. So because of that they have two things that you have to meet in this 1/3 test. So stay with me on it, Michael. Stay with me. Part of this 1/3 test is that investor who's performing those services, that at least 1/3 of their income from all sources in the medical side in the last 12 months must be derived from services that a physician would perform at an ASC. So it doesn't matter which ASC, so long as it's for those type of surgical or invasive procedures performed at ASC. The second element is basically the exact same concept, but 1/3 of all those procedures performed by that physician or those same 12-month period must be performed at that ASC. So it's an income test and a facility test, and it's all about that 1/3 test.
Brad, please, on behalf of the audience and anyone who could possibly bump into this, let's pause. No more regulatory talk.
Oh, yes.
And I want to know, why did you make me and the audience go through this painful safe harbor?
It's vital to understand these rules when you go into doing an ASC, because it impacts your company agreement, it impacts your medical staff bylaws. And if you don't understand that, you can fail to be compliant with your ASC and put yourself in a legal arrangement. And as such, the ASC must be very active and proactive, meaning that it must know about this and then must keep up with making sure that they're meeting these rules.
You can just do what I do whenever a client calls us and they start talking about ASCs and setting it up and this type of arrangement. And I make them talk to Brad. And Brad will fix it, because it's hard to keep track no matter how simple. And believe me, I know the other side of this, and Brad has simplified this stuff so much. But Brad, how does it apply to today's story?
All right, fair. So Dr. Spine was meeting these requirements of this 1/3 test that we talked about. So that was great because it was providing all those services.
What about Dr. Payne?
Dr. Payne was not on the same path as Dr. Spine, because he was still doing in-office procedures, which they were paying him for and he could collect. But remember, we talked about with his ASC revenue, he was struggling either to collect it at all, or he was performing services there and they weren't paying for it at the ASC.
But that was not the only problem.
No. So besides these potential running afoul of the safe harbor, again, clarity here, just because they don't meet it perfectly doesn't make it illegal. Dr. Payne and Mr. Network were also potentially jeopardizing the state license of the ASC.
Well, that doesn't sound good.
It's not. When a state license is issued, it's generally issued to the individual, or in this case, to the entity. So only that entity qualifies to use that license. For a license to be used by another person or an entity, it must be formally transferred with the applicable state agency.
Yeah, and this is kind of inside baseball, is often called a chow, or a change in ownership. And so when filing a chow, there can be a ton of paperwork and sometimes pre-approval required by the state.
Yeah, and it does depend on the type of facility. But so let's just jump back into. So yes, having that state license ASC is a valuable asset because you worked really hard to get it. You get it qualified, and it's now a license. It's something that can be sold. As such, you don't want to lose it because people do pay top dollar for an ASC license, and that's because you have to meet all these restrictions to keep that license. Like that same license can't be used by any other entity if they wanted to, because it's only owned by one.
Okay, so why do you bring this up?
So remember those unethical or questionable arrangements we talked about earlier. Mr. Network and Dr. Spine were going to these other entities and saying, hey, why don't you bill and collect under our ASC license as if it's your own license, and then you can just go off and collect it. And this opens up to a huge block of issues. This includes potential insurance fraud allegations from commercial payers, potential breach of the actual license with the state, and of course, potential versions of of bringing up that little anti-kickback thing that we talked about earlier.
In plain English, I call that not good.
Yes.
Yeah. So once Dr. Spine learned all of this, he was ready to get out of the ASC, as you might imagine. He demanded that Dr. Payne and Mr. Network purchase his ownership. But based on the debt load of the ASC, the fact it was built for Payne procedures and the commercial payers were not paying for these services, neither Dr. Payne nor Mr. Network wanted to buy out Dr. Spine. So this led to the entire ASC being sold in a fire sale, with Dr. Spine having to pay a large portion of the note off himself based on his personal guarantee.
Yeah. So Michael, this season is Zoom In. And so we are going to talk about the details here. Hopefully the audience was able to spot them. with us. But, because Dr. Spine was not interested in the details, it allowed other people to really go through that for him. He unfortunately partnered with a third party that didn't really know ASCs as well as he should have, and was a really good salesman, saying that he had a great network, but unfortunately he actually did not have a great network. And so he had a vision of what he wanted to do for spine doctors in ASCs, and that could not have been more of a different as to what was finally delivered, because he wasn't concentrating on the details. Michael, final thoughts?
Well, we've talked about plain language and trying to make things more simple. And even when you try to do it on some of this healthcare regulatory stuff, it still doesn't make sense. It's still complicated. Mm-hmm. And I would just strongly encourage anyone, if you don't understand it, that doesn't mean ignore it and go forward, and just, ask for help, because, there's a lot of areas in healthcare that frankly don't make sense, and you need a translator. Yeah.
And so, audience, please join us next Wednesday. We will actually have a special guest joining us, Jay Riera, which you may have heard his voice before. But we wanted to talk about this particular episode about the multi-special one. And next week, we're talking about doing one without a license. How can you do an ASC or an in-office surgical center? So tune in and learn more. Thanks for joining us.
ByrdAdatto is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does it establish an attorney-client relationship. Reference to any specific product or entity does not constitute an endorsement or recommendation by ByrdAdatto. The views expressed by guests are their own, and their appearance on the program does not imply an endorsement of them or any entity they represent. Please consult with an attorney on your legal issues.